And we're both going to talk about a slightly different topic now, and this is all about validation orders, really, and the effect of Section 284 of the Insolvency Act. And Eleanor's going to talk about the exceptions to that. And the case I'm going to talk about is a case called State Bank of India and Mallya, which is a recent decision of Mr. Justice Miles from May 2021, dealing with the correct approach to validation orders, and in particular in respect of legal fees, which no doubt be of some interest to many people attending today. Now, the decision was an appeal against the decision of Deputy Judge Barnett on the 8th of February, in which he granted the appellant's application to release some money out of funds held in the court office to meet living expenses and the costs of English solicitors and counsel in the defence of bankruptcy proceedings, but refused to grant validation relief in respect of other costs and expenses, including the appellant's costs of litigation in India. And it's the latter part of that decision below that was subject to appeal. And there's also an interesting point that comes out of the costs order, I think, in this case. But in respect to the first point, the principal issue this appeal concerns is the costs of those Indian proceedings and whether or not validation should have been granted in respect of payment of those costs. The judge below refused to do so on two grounds. The first was that the court's jurisdiction under Section 284 was quite narrowly circumscribed and didn't extend to costs of the kind being sought. And the second reason was that the appellant had failed to provide adequate evidential justification for the order. So in terms of some background, the respondents in this case were banks and judgment creditors of the appellant under a judgment debt that had been obtained in Bangalore in the rupee equivalent of £1.05 billion, including interest, so a fairly sizable debt. In 2013, the banks commenced proceedings under a personal guarantee. They obtained a judgment in January 2017. That was subsequently registered in England, and a bankruptcy petition was issued on the basis of that in 2018. Then in July 2019, the judge made a validation order permitting a number of categories of payments, including domestic legal costs and some living expenses. But as I say, refused payment of various sums that were sought in respect of the Indian proceedings. Now, the application contained a schedule setting out the sums that the applicant sought validation orders for. And as regards those Indian proceedings, it listed outstanding litigation costs of about £500,000 and anticipated legal costs of about £202,000. But there was little by way of breakdown. The banks asked for further information, such as invoices. There was some further evidence, but still no breakdown. So that was the situation as it came before the judge, Judge Barton, and there was an appeal against his decision not to authorise or validate the use of those funds. So I'll just talk a bit about the legal framework. It's probably familiar to most people on this talk. So, as you all probably know, under Section 284 of the Insolvency Act, when a person is made bankrupt, any disposition of property by that person is void, except to the extent that it's made with the consent of the court or subsequently ratified. But there's a sting in the tail to that provision because it takes effect from the date of presentation of the petition. There's an even bigger sting in the tail, I think, of the equivalent provisions that apply when an estate is being administered, because it can often go back to the date of death. But for present purposes, there's quite a big sting there if you're not aware of it. Now, the underlying statutory purpose, of course, of this provision is to ensure that creditors are paid out according to the pari passu principle. That's to say that no one unsecured creditor is preferred over another. The leading authority on this section is the Court of Appeal case, Express Electrical. It was actually a case that dealt with the equivalent provision under the Companies Act, but the judge in this case was satisfied there was no real distinction between the two. And if, at least for this purpose, there are some subtle differences, but not for this purpose. And the judge in the Court of Appeal, or the judgment in the Court of Appeal, set out a few basic principles, emphasised the importance of that pari passu principle that liquidation assets should be distributed ratably amongst unsecured creditors, but accepted that there might be some special circumstances where it would be in the interest of those creditors to justify or validate a transaction. It may be justified, for example, where the making of a payment or the supply of assets is fulfilling obligation under a profitable contract, which may ultimately generate more profit than the resources it uses up, and that could be to the general advantage of creditors. Another example where it may be to their advantage, but perhaps more finely balanced if the business is going to be sold as a going concern. To that, there is another exception that seems to be recognised, and has been recognised for a long time, and that's that exception involves the payments of costs of debtors defending bankruptcy petitions. And one of the first cases to deal with that was a case called Re Sinclair. And perhaps more recently, there's the case of Rio Properties and Al Midani, in which His Honour Judge Maddox considered an application for a validation order in respect of the costs of the defence of bankruptcy proceedings, and concluded that those earlier authorities remained relevant. And perhaps another case just to be aware of on this point is the Lucas decision, which concerned the administration of the estate of Jimmy Savile. And that was a case where there was effectively a limited validation order that was made, and that's generally the source of order that's commonly made in these types of cases, where they're made without prejudice to the ability of persons claiming in relation to the estate to raise points at some later point in time in relation to the reasonableness of the costs that have been incurred. And indeed, a similar mechanism was incorporated into the original validation order made in this case in respect of the appellant's English solicitors, the effect of which means that it remains open to a later trustee in bankruptcy to challenge the reasonableness of the expenses. So what did the judge decide going back to this case? Remember, this was a case really about authorising very significant sums of money in the defence of proceedings in India that the appellant said, if they were successful, would have had an impact on his ability to defend the bankruptcy proceedings in England. So the judge thought on appeal that the first instance judge made a mistake of principle, and said he didn't think it was helpful to seek to specify in advance that certain categories of payment could never be validated, and held that the judge was wrong to hold that the court lacked the power to validate the costs of the Indian proceedings as a matter of principle. But was he actually wrong in the exercise of his discretion? No, was the answer. And the reason for that was that the judge was entirely justified in refusing permission on the evidence that was before him. And as the appeal judge noticed, there was no breakdown of the incurred costs. There was no attempt to justify the incurred costs, no invoices, no bills of costs, no descriptive schedules. And so fairly light on evidence, I think it's fair to say. And of course, the amount being sought was substantial, being about £500,000 in respect of incurred costs, and of well over £200,000 in respect of future costs. And it's also the case that the banks have repeatedly asked for further information, but it hadn't been provided. Now, one interesting argument that came in the discussion was that the appellant said, well, the banks were parties to these proceedings, and so they would have had a good idea about the costs that were involved. But the court rejected that argument and said there are many circumstances, cost budgeting being one of them, where it's not an answer to simply say the other party must know what the level of costs are. And I think, going back to one of the earlier slides, if you look at the evidence that's generally needed in support of validation orders as required by the practice direction, I think it's fair to say that it's fairly extensive. And so it's no surprise that that type of approach was dismissed. I said right at the start, there was quite an interesting point on costs in this case. And that's because the judge below ordered the appellant to pay 50% of the bank's costs of the application. The effect of that judgment was that, as I said, some funds were authorised, about 1.1 million. And on the other hand, the judge refused to authorise about 1.5 million of payments, including the payments in respect to the Indian proceedings. Now, the error that the judge made below was that he started from the point that the bank had succeeded in resisting the application, but overall on appeal, the appeal court took a different view and came to the conclusion that the starting point was wrong. That's to say, concluded that banks were overall successful, and that in fact, on appeal, that the judge thought that neither party was the overall winner. Each party won on some of the points. And so if an applicant has obtained some or substantial relief, but not all relief, there may well be a useful decision to bring to the court's attention on costs, to argue for costs in the case as a result.
Interestingly, Nathan and I were against each other yesterday on a contested matter to Birmingham, but we're being very collaborative today. So it's probably a good sign as to how well we work as a team, which is what today is all about. Anyway, let's launch into Edwards and Aurora Leasing and another decision in January of this year about Section 284, and in particular, Section 4A of that particular provision. Obviously, Section 284 deals with restrictions on disposition of property between presentation of the bankruptcy petition and the making of the bankruptcy order. Let's consider the facts briefly. Nathan, I think you can go over onto the next slide, please. So the bankrupt had been a dentist, and the two particular respondents, proceedings having been settled as against various other respondents, the facts were as follows. Aurora, which was, I think, the third respondent, agreed to lease dental equipment to Wazoo Medical Center. And Wazoo Medical Center was a partnership made up of the bankrupt's parents, not the bankrupt himself, but there was a guarantee that had been provided by the bankrupt. Following presentation of the bankruptcy petition, the bankrupt wrote a check for some 27,000 odd, just under 28,000, in respect of the initial rental of that dental equipment pertaining to the partnership. That check cleared, and at the time when the check cleared, Aurora had no knowledge of the bankruptcy petition which had been presented, and that was an accepted fact by the trustee. In respect of De Walden let premises to Wazoo Property Limited. Now, Wazoo Property Limited was a limited company in respect of which the bankrupt was a director, but he was also a shareholder of that entity. The bankrupt made 3 payments, totaling some 81,000 odd pounds to De Walden, and those payments were allocated to rent for those premises for June and September 2013 for those quarters. Each payment, again, was made before De Walden was aware of the bankruptcy petition. Now, both of those respondents, the third and sixth respondents, set up the Section 284 4A defence, and that provides a defence to recipients where 3 grounds are made out, 3 elements of that defence. First of all, the payment had to be received in good faith. Secondly, the payment had to be received for value. And thirdly, the payment had to be received without notice of the bankruptcy petition. The sole issue on the facts of this case, because it was accepted that the payments were received in good faith and without notice. So the sole issue related to the issue of value. And that was the matter that the court in London was seized of. I've set out here and on the following slide, Section 284. You can have a read of that in the slides hereafter. The preceding provisions of this section do not give a remedy against any person, A, in respect of any property or payment which he received before the commencement of the bankruptcy in good faith, for value and without notice that the bankruptcy application had been made or that the petition had been presented. So those are the three aspects that I've just taken you to. In respect of Section 284, the judge considered that that provision of the Insolvency Act should be considered on its own terms and not by analogy or by reference to Section 127, namely the corporate equivalent. The judge considered, and it's worth reading the judgment, that the Section 127 provision actually contained different and separate distinct requirements. And he said that in these circumstances, I'm assuming it's a he, that the Section 127 provision didn't apply. The trustee's argument that was put before the court was that for value meant that value must be provided to the bankrupt direct or to the bankrupt's estate rather than a third party. So that's what the trustee was arguing on the application. The respondent's argument was that value meant just what it said, there had to be some value, and that Section 2844 was simply a shield for innocent parties. The judge considered that Section 284 had to be taken on its own terms, and that the provision there at Section 4A was very similar to equities darling, which I'm sure we've all come across in respect of property transactions or whatever. So the judge said, no, we don't look at Section 127. We look at that particular provision. We take it on its own terms. As you see there at the second bullet point, the court identified the two main strands of the statutory purpose, namely to provide and preserve estate assets and to preserve their proper distribution amongst the creditors, but that it was a protective provision and it was designed to avoid unfairness. And the defence is an exception to the general rule at Section 284 about void dispositions. We can see that there was no issue between the parties about the two provisions being made out in respect of without notice. And the sole argument was about the value point. The case and the application was dismissed against both of these respondents. And the judge concluded that both of them had provided value. In respect of Aurora, the payment that was made by the bankrupt in respect of the dental equipment was that payment had triggered the purchase of the dental equipment and entry by Aurora into the terms of the equipment lease, so that value had been provided. In respect of De Walden, the payments that were made by the bankrupt meant that the premises remained available for use both by the bankrupt and by Wazoo Property Limited, and again, that value had been provided. Both consequences were intended by the bankrupt as a result of the payments that were made, and these were commercial transactions against a commercial backdrop where it was quite clear that value had been provided. And importantly, as I said at the outset, it was accepted that both respondents were unaware of the petition at the time when the payments were received. In conclusion, therefore, the judge held that this protective section was designed to avoid the unfairness. It didn't have a restricted ambit, but it was part of the statutory provision at Section 284 of the Insolvency Act. It could be construed in accordance with its terms. And accordingly, it could be viewed as analogous to equities darling, that argument that there was a bona fide purchaser of the legal estate effectively for value without notice expressly provided at Section 4A. Noting that there were no qualifications about how the word value, and noting that there was no requirement at Section 284.4a that value be provided either to the bankrupt or to the bankrupt's estate, the judge considered that at the time there was value provided, and that was quite clearly the rationale behind the case. So the judge said, look, the value does not need to be provided to the bankrupt directly or to the bankrupt's estate. It's satisfactory that there was simply value provided by the respondents and the trustee's application was dismissed. Now, this case, when you read commentaries and so on online, has been viewed quite negatively, I think, by trustees who think that actually this is a decision which is a little disastrous for trustees. I think there has been very little clarity for quite a while about the meaning of the word for value or the words for value. And therefore, this authority does just that. It provides that the value does not need to be value which is attributed directly to the bankrupt or for the benefit of the bankrupt's estate. And therefore, perhaps if you're for a trustee, you might be dismayed by the decision, but it provides some welcome clarity and clarification as to the meaning of that statutory defence under Section 284.4a. It's probably worth us just saying that although we have both been speaking this afternoon in the personal insolvency slot, we do actually do a lot of corporate insolvency work. And I personally, Nathan, I'd be interested to know what you do more of, but I personally do more of the corporate insolvency. So it's actually been nice to revisit some of these recent decisions and to remind ourselves of those principles, really, because I think it's quite important not to get pigeonholed into one or the other. So we do the corporate. We just volunteered for diary commitments to speak this afternoon.
Yeah, I think that's right. I mean, we both do, I think, a lot of commercial work. I certainly do, including commercial property work.
Yeah.
Which, is an area that we both do quite a lot of work on. And I think there's been quite a lot of overlap recently between that and insolvency areas, in particular for landlords trying to deal with situations they found themselves in throughout the pandemic.
Dan's question here is an interesting one. Leslie or Louis or Laura, whoever, feel free to weigh in as well. Jan, I think yes. I think it probably does. If you've got, a shrewd bankrupt is going to think, well, actually, how can I get around this? The full value point is potentially one that operates favorably if you're wanting to dispose of money or dispose of those types of elements with some foresight. I suppose you would need to think long and hard about it, but I do take the view that it is probably of benefit to someone who's forward thinking, for sure.
Eleanor, just for the benefit of everybody, the chat is just with us and the panelists.
Oh, sorry.
So just the question concerned was, do you think this case then encourages the well-informed prospective bankrupt to use funds for third-party benefit? Sorry to chip in.
No, that's grand. In answer to that question, Jan, yes, I think so. And I'm grateful to Leslie for reading it out. I think, if you do have a well-informed bankrupt who looks at that case and says, well, actually, forward planning, I'm going to make these payments or potentially with a view to relying upon, or some third party relying upon that statutory defence, then yes.
We've got another question in the Q&A as well. Do you think the Edwards decision leaves open a potential loophole, allowing a bankrupt to distribute their assets for the benefit of third parties? And he goes, this is from Jacob Walker, he goes on to say, full disclosure, this was our case and we were on the losing side.
Oh, okay. Well,
Thanks, Jacob.
I'd be interested, Jacob, as to how you might answer that in due course. But presumably, you were instructing Ian Tucker, were you? I don't want to commit overly, but I think there's a risk of that for sure. And obviously, the trustee, I would have thought, would be very disappointed on the facts of that case. But yeah, I think it does leave that argument available, as Jan has identified, and I think it does potentially leave that loophole to be exploited by someone who's a little bit savvy.